our meeting of the Ad hoc Ordinance Committee Review Committee to order. And we are going to start with the Pledge of Allegiance. Jim, would you lead us?
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Is there a pencil in there?
So there is, it's called Jim's writing.
The little whatever got lost. Okay, that's cool. You're very observant, Vince. Good morning, everybody. I'm going to turn on Sandy's mic. Oh, it's still on. So that she can do a roll call and we can all be reminded who's on the committee.
Logan,
Present.
Bullock, Butler, Freeman, Newquist,
Here.
Richmond,
Here.
Trenier.
Present.
We have a quorum.
Okay, and first thing up is the approval of minutes from the August, nope, sorry, I'm looking at the wrong agenda, the September 9th. No, oh, yes, September 9th, 2025 meeting. Can I have a motion, please?
So move, Logan.
Second, go ahead. Second new list.
Roll call, please.
Logan,
Yes.
Butler,
Yes.
Freeman,
Yes.
Newquist,
Yes.
Richmond,
Yes.
Trenier.
Yes.
Motion passes.
And the motion carries. Next up is public comment, and looking out into the audience, we don't seem to have any public, which does concern me because we had some people we were hoping were going to be here today. Any public comments? Somebody want to go out in the hallway and drag somebody in? No. So we're on to old business. First one up, 25-23, amending chapter 51 of the Code of Ordinances. And if I recall correctly, we postponed that in September because we needed a Mr. Connors to be here. So Mr. Mock, can you tell us what we're going to do today?
You don't know. I met with Mr. Connors and
Okay.
Member Butler and discussed some of these issues. And when the meeting ended, I talked to Mr. Connors and said, would you please still come to the meeting? And he said he would, but I do not see him.
Can we call him? Where's he at?
Health Department.
I don't know if we can get somebody from staff to call him. I mean, they're not 10 minutes away. I mean, unless he's in Bolingbrook at the
No, no.
environmental.
No, I think he's at Ella.
No, I meant like
Yeah.
for some special
Yeah.
issue, reason, whatever, maybe he's sick today. I mean, I don't know, but
I mean, that's. no,
they're
but
10 minutes away. I say we should call him if we can get somebody to call him.
Well, did any members have questions
He's
from other,
environmental health.
did any members have questions from other than Member Butler? I thought he addressed all of Dan's concerns. If anybody else has any, we may be able to do it if there aren't.
Let me page through here. I read this yesterday. I didn't really have any concerns. Was there anything that got changed after
No,
Mr. Butler and Mr. Connors talked? Okay. Member Newquist?
there was some
Yeah,
explaining done.
under 51.01 purpose, we added C. The version I got from Sandy had C added, which our old version did not on page 1. The property owner is solely responsible to ensure compliance with the provisions of this chapter and state environmental regulations notwithstanding.
I have that in my copy.
I didn't have, that was not in our original.
Right, but it's in the one you got.
Right, but
today.
we added that.
I did that, I
Yeah.
did that on my own just to make it
Right.
clear.
Yep.
Okay.
That didn't have nothing to do with,
So that's basically just saying that it's up to them to comply, even if somebody from another government agency gives them the wrong information.
Right.
Okay,
So,
and so, you know, the reason I put that in too, there is a principle in the law called collateral estoppel, which means you can rely on the other people's information. And if you do, then it's not your fault. There's a specific carve out for governmental agents. There's no collateral estoppel against government agents. If a building inspector tells you to do something and he's wrong, that one building inspector does not have the ability to overrule the municipality or the county that passed a building ordinance. That's why there's no collateral estoppel against agents. One of the biggest cases on that, there was a sign case in Chicago where a person was permitted to put a sign on their outside of their building and it was there for 20 years, but it was in violation of the ordinance. And they took him to court to enforce it, and he tried to argue collateral estoppel, saying, you can't enforce it because you gave me a permit and you let me do it for 20 years. And the court basically ruled, yes, but when they gave you that permit, it was in violation of their ordinance. And the person that issued the permit to you is not a supreme being that can overrule what the governing body did. You need the whole governing body to change the rule. And that's why I put that in there, just so they know.
She's trying to get a hold of.
You know what? Tell her, forget it. It sounds like everybody's good.
Oh,
I thought there was some big deal going on, but apparently, Mr. Butler, are you okay with the explanations you were given?
Yeah, I mean, this.
Turn your mic on, please.
This explanation is slightly, you know, in my opinion, slightly better than what was offered previously, because I would say that maybe some intelligent people with understanding of government would understand what's being said here. And before, you had to be actually a lawyer probably to really understand the significance. The only thing that I would, you know, I would have wished for a little bit of language that would have been a little bit easier. Like instead of saying notwithstanding, I would rather that had said regardless of, you know,
You can move to amend notwithstanding to regardless of.
just so a person who reads this understands like, hey, you are responsible for this.
To look that up to make sure I was applying it correctly. So yeah, if we can change, if you want to make a motion to change it to regardless
Yeah,
of,
yeah.
Mr. Logan will second it.
I just have one more
And
question.
well, on this particular sentence,
The sentence that we we're just talking about in
Yeah.
C, yeah.
okay,
So, and I don't mean to be a stickler about this, but what if, like in your example of the building inspector, what if the building inspector actually gave them incorrect information? I ask because this actually happened to me when I had a
Well,
commercial
that's exactly what he
building.
said. It was incorrect,
If
but
it's
he's not a
incorrect,
supreme
you
being.
can't hold them to it.
You can't hold the person to it.
You can't hold the unit of government to it,
inspector.
the inspector.
Okay, so in my case, it would have required me to rip out previously installed electrical because the building inspector was wrong. I argued, I mean, I basically pitched a fit because it would have cost me thousands and thousands of dollars to correct the situation after I was given the okay. So, I mean,
You would have you could attempt to go after the building inspector individually, but you wouldn't be going against the unit of government because, again, he can't overrule the unit of government. And part of that is so you don't have bribes and things like that. Not that that's
Right.
your case, but that's what part of it's for.
so how do you know? If a government agent gives you bad
You don't.
information, how do you know they're giving you bad information?
You never know. It's sort of like you're presumed to know all the laws even though you don't know them. And
that's true. You're expected to be aware. Ignorance of the law is not an.
And so that way you may want to have your electrician confirm that it's within code. So you got somebody you can sue. Because that way you have a fall guy. What you can't do is defeat the governmental's mechanism for how they want things to be safe.
Wow.
Or you'd have to go to court and say that the government's mechanism to make it safe is like ridiculous and not realistic and it should be unconstitutional. That's your two ways. You either try to throw the whole law out or you try to get your own contractor or employee to be on the hook for it. What they don't want you to do is try to put the government on the hook for it.
Got it. Well, they ended up grandfathering me in because it was a previous building.
And if it is,
Then he was
and that is
referring
the law.
But,
Yeah.
Yeah, that is the law.
With a lot of things. All right, can we do a vote, a roll call on the amendment?
What the motion is
Sure,
actually.
amend the language
To-
in 5101
To-
C, strike the word notwithstanding and put in regardless of.
Yeah, strike it.
Much more, less legal ease.
Strike the word withstanding.
Notwithstanding,
Strike notwithstanding
Uh-huh.
and insert
regardless.
regardless of.
Sandy here, strike that word and put regardless of, I'll send it to you.
Okay, thank you.
Okay. All right, and then can we have a roll call when you get your notes done?
You have a motion. You have a motion.
And I have a motion and a second.
Second, oh, we have a second,
Mhm,
okay.
Logan.
Logan,
Yes.
Butler,
Yes.
Freeman, Newquist,
Yes.
Richmond, Trinier.
Yes.
Motion passes.
Okay, and now we need a motion to send this to the executive committee as amended.
Motion Newquist.
Motion by Newquist,
Second?
second by Butler. Can I get a previous roll? Previous Richmond,
Second Logan.
second Logan, all in favor?
Aye.
Those opposed? Motion carries. Okay. We are on to chapter 55 Code of Ordinance, Stormwater Management. And I understood that there was some questions here and we were hoping we were going to have somebody here to answer these.
Yeah, I talked to Brian Radner. He was supposed to get us somebody. He didn't tell me who it was because he said he didn't know. They just tried to call. I don't know if
Before them.
somebody, that's what we were talking about.
Yeah,
Can we pass 55 and go to 56 and then maybe they'll
maybe
come
they'll be
over?
here. Yeah, yeah. Do we need, is everybody okay if we just go to chapter 56? Do I
Yes.
need a motion? We're all okay? All
We
right,
have Unanimous. consent?
unanimous consent. We are going to go to chapter
Can I make a
56.
comment about 55?
Yeah,
You know, 55, I mean, I have absolutely no clue if anything needs to be changed.
I think that's why we need somebody
Yeah,
here
I
from
mean,
Stormwater.
I think, right, we basically just need those guys to tell us. if
Yeah, a lot of
something-
this stuff is like that. It's kind of over our heads.
Right.
A little bit, because these are expert officials that
So,
are,
so you know, I spoke back probably in May this year. I spoke to staff that handles stormwater management. I sent over to Brian Radner this whole section
Mhm.
as I proposed it to be. And he came back and said that he didn't have any concerns or problems or issues and that it matches the way we're doing things now. And so basically, all I did was clean up language
right, and the numbers.
in the numbering and striking the, you know, the old resolution numbers out and stuff like that.
Mhm.
But this is how we actively are handling it. It's still in conformity with these statutes. I'll admit, the last time we've looked at it was 2004, but the statutes haven't changed since then either.
Right, and I'm
I do have-
guessing we looked at it because of solar, because I think this is where I read this section about how they count
Right,
the land that is.
Impervious surface.
impervious.
right. That was the only update on it at all, but that was recently done
Yeah,
too.
And I
exactly.
do have a question about
Mr. Butler?
impervious
I will
surface.
recognize you. Go ahead.
You know, I think the question was that they gave the solar companies kind of less restrictions on impervious surfaces than they gave like a farmer or like
Can you
someone.
give an example?
Well, I don't know if you're familiar with Navarro Farms.
No, but can you,
So Navarro Farms is it's a non-for-profit and they, it's a place for, young, mentally, impaired or
Challenged.
developmentally challenged people to kind of commune and work, like raising vegetables and selling them, making little things like for the cottage food industry. And, you know, they had stone out on like a driveway and they called, and then they wanted to build some greenhouses to grow vegetables in the cooler weather. And they were trying to get a permit and they couldn't get it because their impervious, surface area was too large. They were gonna have to build a retention pond, which would have taken up, you know, a lot of their land that they had for this non-for-profit. And it just seems to me like a lot of this area was just stone. You know, like I can understand if it was grade 8 stone that gets compacted and it's like when you drive on it, it's almost like concrete. But if it's just like 3/4 inch stone, the water goes right through it.
Yeah.
And it just seems like with such a, like an organization that does so much good, that we would like put all these extra constraints on them, you know, when they're just trying to.
Yeah, I can understand what you're saying, but
So
we don't
if
create
it's-
laws for individual organizations. They do have other options. Had they considered doing a hoop house
Well,
instead of a greenhouse?
I'm just saying with the impervious surface,
Mhm.
any roof that they put up is gonna be in part of that impervious surface. So whatever they put up there. But what I'm saying is,
Okay, it's more about the roof,
when
not
gravel
the
is,
base.
when gravel allows water to drain through it, it is it's not an impervious surface. Water drains to it. So I wonder if there's not something in our codes that says, what type of stone?
Okay,
Because grade 8 could actually, I could see would be that, but
Mhm.
not like 3/4 inch.
fine, and the water rushes off the sides, sure. Well, hopefully somebody
Compacted.
will come and be able to explain that to us, because maybe we should have a second section in there dealing with just gravel driveways. I'll just call it a gravel
Yeah.
driveway.
Mhm.
Because that's really what it is. Not a gravel road, which is more toward the impervious side, but it's a gravel driveway.
Well, I think it's more or less the size and the
Mhm.
compaction.
Yeah,
So
when
if
you
it's
drive
small-
on those gravel country, township, country roads, farm roads, it is really small gravel. There's big gravel too, but it's really small. And year after year, they keep
But-
adding more, and it is very compacted.
That may be more of an enforcement issue, and here's why, or an
Mhm.
interpretation of enforcement issue. On page 12 of what we provided you under the definition of impervious, it says surfaces that cause the majority of rainfall to be converted to direct runoff, asphalt, concrete, and roofing systems will be considered impervious, which means
It
a
should be-
gravel road doesn't necessarily have to be considered impervious.
So it sounds
Whoever
like,
made the inspection at that
business.
time made a determination that they thought it was impervious, and that's something they maybe could have taken up an appeal process to the
Mhm.
supervisor of that person
Well,
or
that,
somebody else, because they just said, well, that's impervious and we're counting that as
Right.
impervious. If they would have pushed back as you did and said, look, it's gravel, it's not, because I was at stormwater meetings years ago after we first passed this.
Mhm.
And they were saying there that gravel was not considered impervious because water will percolate through it.
right.
So it sounds to me more not a ordinance issue, but an enforcement issue.
Yeah, they
Okay.
should have pushed back.
That maybe we need to talk to the land use people,
Okay.
ask, why are you coming up with that? Or do you have some statistics we're not aware of that shows that gravel, because I'm with you. They said that gravel is not considered
Right.
impervious because it will let water absorb.
Yeah, let's see what they say if they show up today, but I would agree, it's a little bit like what Member Newquist was talking about with her situation. You got to push back. If you don't push back, you can have an inspector or somebody come to you, make a ruling, and it's wrong, and there's not really much you can do if you don't push back.
Right.
So, Member Freeman.
So, I understand we're gonna wait and see if someone shows up, but if they do not show up, I would think I would be okay
Me too.
letting Phil, Mr. Mock find the answers and get back to us at executive next
Yeah.
month and pass this.
Yeah,
As
we can
is.
pass it as
Thank
it
you.
is, and
We can
Get
amend it. We
clarification.
can amend it still there,
at
right?
executive.
Oh, yeah, executive, you can always amend.
For sure.
One question.
Sure.
Do you want me to wait?
No, hit your,
And thank you. I'm not exactly sure why I flagged this, so maybe you guys can tell me if we talked about this or not. But under, on page 17, requirements for stormwater management, 55.020, general information. I had a question mark by number C, existing multifamily or non-residential land uses on a site 1 acre or more in size, in which new development after the effective date of this chapter in the aggregate exceeds 25,000 square feet. I think my question was, what do you mean in the aggregate, like?
all
and-
of them combined, the new and the old.
Yeah,
if it was more than 25,000 square feet. And I suspect at that point, and Phil can maybe enlighten us, but
we,
I would suspect they would then want a retention pond.
But this says on which new development.
Right, if you add more stuff and you add new development.
Right, if it was over 25,000 square feet, but it was already existing, it's grandfathered in for lack of a better.
Got
term.
it.
But if you add
Okay.
But if you
something,
add to get over that, then you're
Then
covered.
you're okay, thank
Mhm.
you.
yeah, I would suspect at that point, you're expected to add a retention pond or some sort of.
And unfortunately, even if you're over 25,000 square feet and you're adding on, you got to meet this standards
bird.
for the
Rating.
attention pond that would have even been less, that would have been under the 25,000. You got to do the makeup then.
Yeah.
So you're grandfathered unless you make a change.
Right,
Got it,
basically.
which makes sense.
It could, because otherwise it would be a taking without just compensation, and we would have had to pay them to fix the situation and follow it. That's why all those grandfather provisions are usually in there.
Okay, thank you.
Okay. Yeah, let's hang on and see if the person comes from that department. In the meantime, we have Chapter 56, Public Works Permit and Access Control Regulations. And I know I had some questions in here, and I had some questions
Sure.
about stuff that maybe isn't in here. And I will just
So you-
preface it with a statement about what I've been asking the state's attorney about. And that is, in every one of our meetings, no matter which board, whether it's Forest Preserve or County Board, we always have to have a motion for permission to bid, permission to go out and seek bids. We don't seem to do that in the Public Works Department. And so I've been asking, under what authority? And it's not like I'm saying we can't do it the way we've been doing it. I just want to know what authority that a non-elected person that isn't, a non-elected person gets to go out and solicit bids for something without asking us first. I understand that our role is to either approve or deny the final bid. But we've made these vendors, this is in Public Works, just overall.
Oh,
I'll explain
got it. Okay.
my question. I'm giving you some background. Why would you want all these vendors to go through all this work if you're just going to deny, no matter what the price is, you're going to deny the bid because you don't want that road to be built? So, Mr. Mock.
Okay. The director of the Department of Transportation, county engineer, they use the terms interchangeably, is technically a state employee, even though you appoint him. The statutes give him all of his authority under the highways code,
Okay.
not under the county's code.
Okay.
He has his own authority to submit for bids under the highways code, just as a township highway superintendent
Mhm.
or the state Department of Highways, they differ, or the municipal highway
Right.
departments.
No, I get what you're saying.
So he gets to do that without asking permission. However, the statutes do say, since it's an expenditure of funds, even though the funds are segregated to him, you must approve the expenditures.
I was waiting for the answer. I guess Dan worked on it for quite a while and now he's off on leave for some reason. And Mr. Myers was reviewing his answer and didn't think it kind of gave me everything I was looking for. I just wanted to understand the process. I wasn't
But-
arguing
but no,
about
no,
it.
but that's why it's that way, because he gets his authority under the highway code, and the highway code specifically gives him the authority to bid out road projects.
So the reason I asked, why I gave all that background information has to do with page 7.
Okay.
There's something there called the Coordination Council. And that is just the county executive and the county engineer. Now, originally, that was supposed to be the county engineer and the county board chair. And they just replaced that with executive. I don't know that that is the intent of the state statute, I guess.
That-
And even if it is, shouldn't the county board speaker also be on that coordination council? So that was my question. That's why I brought up the background, that it seems like he does things without our permission, but this council and his authority apparently from the state gives him permission.
The reason the county board chair was taken out and made the county executive is because when the County Executive Act was passed, it said all duties previously of the county board chair is now a duty of the county executive. So automatically by operation of law, that switched.
Okay.
I'm fixing our ordinance to match what the law actually says now, because my understanding is it's operated that way since we've had the county executive, even though our ordinance said the county board chair needs to do it
Okay.
because of that.
That was what brought up my question. Did anybody else have questions? I know Member Freeman, I turned your mic on.
I was just gonna say kind of what he said. I remember this discussion. It was like
In other
2020,
chapters.
21, right after that was passed, because we assumed that
Oh,
the
you're thinking about
wording
Senate Bill
board,
1015.
the board chair county board chair refers to our speaker, but legally they think that's.
I have a question.
Argument, though, and it came up with the 708 board about who gets to do the appointing. And I don't know who decided that at that point it was going to be the county executive, but that, yeah.
But I also had it in my like little notes about should our speaker
Mm-hmm.
be part of this?
Yeah,
Because I tried to find coordinated council in the
yeah.
statute that's listed and I couldn't.
Because
So that was another question I had. But then
Yeah.
my other
we
question,
can change it maybe.
my
I
other
don't
question
know.
for you is, are we gonna start at the start or are we just jumping around?
We're
So
going to 56. I
Right.
started at the beginning. I mean,
I do have one question.
yeah.
Because I had a similar question about that. When they talk about the chair, are they referring to the chair as before there was an executive, what their relationship was to the transportation director, not necessarily the chair underneath the executive?
This was originally passed before there was a county
Yeah,
executive.
yeah.
And the county board chair, basically his job was to handle all executive affairs of the county because it was too hard to get 30 members together to vote on something. So the statute said the county board chair can do all these actions that have to be done fast. And then later it gets approved by the full board because something's an executive action, but they want it ratified by the whole board to make sure that you don't have a crazy county board chair that just does whatever he wants to do or she wants to do. Then when the county executive statute was drafted, it said
Yeah.
all the executive functions of the county will be handled by the executive. And it specifically said all the times that specifically said the county board chair shall do something. It's now the county executive does that because the county board chair was doing an executive function with that terminology that was in the statutes.
Nope, thank you. That really is clear, because that has nothing to do with Senate Bill 1015, which was passed in
And,
2020.
but when they passed Senate Bill 1015, they specifically mentioned certain carve-outs,
Mhm.
and they could have done it with this one too, or any other one. They could have again, because all power comes from the state in Illinois. There's no even home rule units. The state can take their power away. So the state legislature, if they wanted to, could have said, you know, the county board chair / speaker, we want doing this function instead of a county executive in that system, but they haven't chose to do it yet.
Okay. Member Newquist.
Yeah, I was just gonna say, remember, there's 100 other counties
Yep,
where the county board chair is essentially the county executive.
yeah.
I mean, so, and I'm not opposed to having the speaker on the committee, but I don't think that was the intention of the statute. It doesn't sound
Yeah,
like.
now that he's kind of gone into a better explanation, I kind of get it. Because we still do hold the purse strings. I just thought that it
It's
can be,
confusing.
yeah, it was just confusing to me. So yeah, we're at the beginning. If anybody has any questions on any other part, that was just, I think, my only question. I don't know if anybody else has questions. I did find another spot, page 19. Number 23, they refer to the county highway tax fund. That's not the motor fuel tax fund that we get from the tax,
No,
from gas tax.
That's different.
This is the other one. This is the one that some of us have wanted to reallocate that money elsewhere. Because we now have the motor fuel tax fund, the gas tax. Just.
And I did check, we still have a county highway tax fund because I
Mhm.
checked with
It's
the
pretty small.
treasurer. Yeah.
I wanted to reallocate it to the health department this year and next year.
I had no clue from this.
But that was, I think, my only questions.
Yeah, I mean, this all looks pretty cut and dry to me. I mean,
Yeah,
it's mostly
said-
just, you know, definition.
You have to realize some of this was amended in 2020 and also certain things that the county board does, like transportation stuff,
Mhm.
zoning, you guys are updating them all the time because when you see a problem, you fix it. A lot of the stuff we dealt with, like I said, there's some that hasn't been changed since 1980.
Right.
So this one should be relatively,
Well, you added a new
Right.
section on page 36 and 37, pretty big section, actually. But I think it's just because there were changes in the widths and the distances.
correct.
You struck out the whole other section, so.
Right, they did change the right-of-way requirements. And what happened,
This was, oh, go ahead. I was just gonna ask you a question about page 41.
yeah, I got this information when I did it from, again, I sent it to the highway. I talked to, I don't think it was Jeff, he assigned me somebody to talk to.
Mhm.
And they said, no, that's not what we're doing. That's all wrong. We got to fix that. So I struck out whatever they told me and I used whatever they said is the current standards that we're following.
And they have this copy now,
Right,
right?
they have this copy.
Okay. On page 41, you put an interesting line in here that I thought different than anywhere else I've seen. Under 56.102B easements,
Right.
the red line is this policy has been in effect since at least 2006. I've never seen you write something like that before.
I did that because up on Weber Road,
Oh, boy, my neighborhood.
when there was a big fight, I think with Nicor,
Uh-huh.
when we were widening our road and there was an issue about the easements and the granting of easements. And there was a fight. And when I dealt with Jeff at Highway and we were discussing it and stuff, he pointed in, it was a fight we ended up losing. We had to pay to move their lines.
Was that the Weber Road interchange?
Yes.
Yeah, I remember.
We had to pay to move their lines.
Hmm.
We wanted to put in here that the policy about new utility easements shall not be allowed in the county right of way, and that it's been in effect since 2006. So if anybody ever was found to put or claimed their easement within a county right of way after 2006, it would be suspect immediately.
Okay.
And we would take it and say, well, you did that illegally because our policy has been since 2006 not to allow you to do it.
Okay. Good.
And that was something he asked that I put in and I put it in for him.
Member Newquist, do you have questions?
I-
Oh, Member Freeman.
I
does.
I'm
Your
just gonna
button,
share
girl.
her.
Yeah,
because
no, I do, but go ahead, Mike. I'll ask mine after. you.
Mine's pretty quick. It's on page 38.
Mhm.
Number 6 on that page, right before the maintenance of driveways and streets. It says the right-of-way monumentation will be outlined in the technical reference manual. Where's that book at?
The technical reference manual is not, it's adopted by reference. It is a manual that's put out by the State of Illinois Highway Department, Transportation Department.
DOT.
And DOT does it, and it's called the Technical Reference Manual. So when they opt to update it, it's always going to be the current version.
But that's
Okay.
the state's
That's
technical
state.
reference.
Right, that's the states, but again, we have what's called a uniform Department of Highways.
Right.
Even though the state does it, the county has to file the state standards, townships have to file, municipalities have to
Right.
follow.
Thank you.
This is more of a philosophical question. On page 16, 56.027, interpretation and separability. It's really the only chapter where we have a section on this. And to me, it's basically saying that if something is, judged by a court of law to be invalid, it doesn't affect anything else that wasn't specifically referred to in that, judgment. But
Sounds like
wh-
grandfather.
why did we, I'm just kind of curious, why we have this in here and not anywhere else?
I do not know, other than the fact that it was already in there.
Okay,
I don't know when they put that in there.
Is it
I-
a state thing though?
No, it's sort of contract language. And it's also in some state statutes. They specifically mention that if one part's unconstitutional, if you can save the rest, you should save the rest. Because there is a common law theory that if one part's unconstitutional, the members wouldn't have voted for it unless they got that part too, so we're wiping out the whole law.
okay,
That was the original old-timey fallback position, that if it's a 300-page bill and there's an error in paragraph 5 on page 6, it killed the whole 300-page bill. So most all of these bills now have this severability language that specifically says, and they're in contracts too, that if one part of it is found unconscionable or illegal
whatever.
or unconstitutional, the rest of it will stand if it could, if it doesn't attack the ultimate purpose of whatever you're doing. We wrote this into this permit and access control regulations. I don't know why it is in here, to tell you the truth. It was in here for as long as I can remember. So, a lot of times in the olden times, the state's attorney's office wasn't as involved in writing any ordinances or reviewing them. Every group would come to the county board with their own ordinance that they pasted together from other people's ordinances.
We were talking about that as it pertained to cybersecurity. And so staff is now going to go look and see what other counties have done in terms of an ordinance regarding cybersecurity. So
But my answer is, I don't know why it's there.
okay,
That's what it's telling you.
yep,
It doesn't tell us that in other ones. We could have put that in every one if we wanted to. I don't know if there's the legal need anymore,
okay,
because they're getting away more from you throw out the baby with the bathwater story. Now it's not really interpreted that much, but it used to be strongly interpreted that way.
so then maybe this is old enough that it
It was
was,
written in here to be
got
cover
it.
all, and it doesn't hurt to have it in. But I
Okay.
understand your concern. Why don't we have it everywhere? We
Yeah.
could have put it
Yes.
everywhere, but we didn't.
Okay, thank you.
there were a couple things like that when I was
And-
looking through this.
And
one.
again, when I went through these,
Mhm.
if I didn't find it not supported by statute or not recommended by the people that actually do the nuts and bolts work with it, I didn't bother changing it because I figured the county board was happy with it before, leave the language the same.
Don't fix it if it ain't broke. Anything else, you guys? Nothing? This was boring to you? Put you to sleep in the bathtub?
And,
It
and
did me.
if we can go back to that interpretation, right above it, there's a repealer and savings clause. You don't really need that language in there either. That's another state thing that they have. In the state statute on statutes, they have the repealer and savings clause. But it's same thing. It's a catch-all. And I assume whoever wrote this originally took those type of languages out of the state. And that's why they're in here.
I lied, I do have another
Yeah,
question.
Go ahead, turn on your mic.
Okay, on page 46, letter C, this is under, bicycle and pedestrian facilities. It says the county is not responsible financially or otherwise for the design, engineering, or construction costs of bicycle or pedestrian facilities located in or outside the county right-of-way built as part of a permitted project. So we have, contributed to like bike paths or pedestrian paths. Is this saying that once we build them, another unit of government is responsible for them?
No, that's not what it
We
says.
are doing it now, Phil. Any road, like when they built Weber Road up north by me, they put no sidewalk in. So now the Forest Preserve is putting a sidewalk in. But the rest of the places now, they work with the local municipality or the township and find out if they want the sidewalk or whatever. And I believe, and I wish Joe was here, he just went by and left, but they pay for a part of it now.
But what this is referring to is not our work, part of a permitted project. Walmart's putting in a new store in the middle of
Got it.
the magic words are part of a permitted project, not a project we do. We don't permit our own projects. We just build our.
Thinking a permitted project is one that we're doing.
No, no,
you
no, no.
know.
Permitted means
Got
you're
it.
allowing,
That's who when I
you're
read it.
allowing somebody or you're requiring somebody to put a turn lane in. Or you're requiring, because of whatever their subdivision is, a brand new subdivision comes. We haven't had a lot of those, but for a while there, we were having them right now.
143rd Street, a brand new townhome
And
subdivision.
if we tell them you gotta have a bicycle lane in all your right of ways, that means we're not paying for it. We're requiring it, but you have to pay for it.
Got it.
Okay,
That makes sense.
okay.
Thank you.
Yeah, I thought of that when I looked at it and then I forgot to put a star next to it. Because I thought specifically about some of these projects where we've said, and I think they were like out in the Wilmington area where we're gonna do the sidewalk or the path, maybe on 53 or something.
And I think that's why they suggested to me to add that part on,
Mhm,
because otherwise it does read like we're never gonna put bike paths in, and we do it.
we do.
But we just want to make sure everybody knows that if it's part of your project, you have to do it. We're not doing it for you. Like, we're not going to subsidize it. We always have the ability to if we want to, but we don't have to.
All right. Anything else, guys? Nothing? All right, well, then I will take a motion to send this to executive committee.
Motion Freeman. Second Newquist.
Can I get a previous?
Previous Logan. Second.
Previous Logan, second Butler, all in favor, say aye. Those opposed, motion carries. All right, we still don't have anybody here from land use or stormwater or any of these other things. I mean, we can certainly go through this. I don't know what the concerns were last month, but, and as Member Freeman suggested, we can send it on to executive and try to get somebody to show up at the executive committee who might be able to answer any concerns. I don't know what the thoughts are. Mm-hmm.
Asked last month for someone to explain to us the difference between.
Oh, turn your mic on. Go ahead, member.
We asked last month for someone to explain the difference to us about the solar panels as opposed to like other residents with the stone. So I would like somebody to, from
Well-
land use to come down here and talk to us about it.
I think our state's attorney representative here, Phil Mock, kind of explained it. The gravel is not considered impervious according to what this says.
Well, I'm just saying that we give the solar area, facilities more lenience than we give regular, homeowners or residents. And so I wanted that explained.
Can
Okay,
you
what-
tell me where that is?
That's a legal issue. I think I can explain that.
What?
That's a legal issue. I think I can explain that.
What
Oh,
page
okay.
is that on?
Yeah, let me find it.
I think maybe it was
Read
9.
last night, but I remember them talking about what is considered, yeah, there it is.
Yeah, the reason that's in there, and you guys just passed it yourselves in 2022, that was after the state took away a lot of your authority to regulate solar institutions. Because prior to that, you would consider all solar panels to be a rooftop.
Right, because they cover the ground.
Because even though the water can like run off the end of it and then go under them, it was still considered a rooftop.
Right.
And when the state basically, as I explained before, sometimes decide we're going to control all that authority and you don't
Right.
have zoning control. And we're going to let you do a solar farm from property line to property line because we love them so much. We're not going to make you have all these setbacks and other theories. Part of it was dealing with the runoff and you couldn't
From the
then,
panels,
you couldn't regulate them by saying they're rooftops.
right.
And we wrote this in order to have some direction to say you still have to have enough impervious surface underneath the solar panels to let the water percolate through.
But did you read the last sentence in number 2 there? Because they're talking about gravel.
Right.
And I don't think that's impervious. The pavement, asphalt, concrete, panel posts absolutely are impervious, but the gravel? And that's what you were saying before, that gravel doesn't count. It's only, what did you say, asphalt?
Well, no, I said under our definition, gravel can count.
Oh.
They said asphalt, concrete, and something else must count. You can't uncount those.
Must.
But
Okay.
they didn't put gravel in the must. Here, under this section, they did put gravel in the must.
Where-
They don't want you graveling under these. They want you to have props or dirt, plants.
And I
Something.
think my comment last month was that some of these pavilions that have, gravel, that doesn't have, cement or anything like that, why would they be treated different than the solar panels as far as square footage? Because they add it up, then they're very strict. And, the answer is you have to dig a retention pond if you're over 25,000. And I just thought, it should be the same across the board.
Well, on this one, it's stronger for solar farms
Yeah.
because they must include gravel as impervious.
But on anywhere else, they don't
It's,
include.
the other
gravel.
one else, it's not mandatory, it's may.
Mhm.
So this isn't saying that gravel is acceptable on solar farms. It's saying if you have gravel under your panels, that's considered impervious because they're trying to encourage you not to put gravel down. And a lot of the companies would rather put gravel, then they don't have to pay for grass cutting or any of that, sheep, upkeep, whatever.
Yeah, that was the only section I think that was really new.
And but that
in
That
this.
was new because, again, that land use told me to put this in here because of the fact that you've already had a separate ordinance you passed in 22 addressing this, but it was never incorporated into
Here.
the code of ordinances. So I took the language that you passed directly out of ordinance number 2224 and added it in this location because it was the appropriate place to put it.
Okay, but the other ordinance still has it. I mean, 22, 24.
That one's still in existence, yeah.
Okay,
But if people
just
looked it up, they
duplicates
wouldn't
it.
have found it.
right,
I would be okay.
yeah.
That's the only question that we.
Oh, sorry, turn your mic on.
Oh, I'm sorry. I was saying I would be okay with moving this to executive. I mean, only because I don't know how without, land use input, we could even address any of these anyway. I mean,
Yeah, I'm fine. I don't have an issue. Make
all
a
right, I'll make a
motion.
motion to move this to executive, chapter 55.
Should move it to the executive, not to
just move it to
postpone it till
executive.
next month.
We already postponed it once. She just wants to move it to executive. If we don't get the answers at executive, you still have the right to postpone it.
See, someone from land use is executive.
Yeah, I would think so. Yeah. I swear somebody from land use was here for the landfill committee.
I talked to both of them and neither one of them had enough information to know stormwater stuff. They
Okay,
said there was two, even when I talked to Brian Radner, who's the supervisor, he said, I don't have enough to know how to do it. They
okay,
have two engineers that they're gonna be down to one because one's moving on.
okay.
And there was a gentleman and a lady that were the engineers and they said, the guy's like leaving soon. We need the lady. And they tried to get a hold of her and they couldn't.
Okay. Well, you want to do a roll call or are we going to do previous roll?
I am gonna be a no, but I'm sure that it'll go through
Let's do
anyway.
roll call. Thank you, Sandy. There you go.
Excuse me. Logan,
Yes.
Butler,
No.
Freeman,
Yes.
Newquist,
Yes.
Richmond,
No.
Trinier.
Yes.
Motion passes.
Okay, motion carries. We are now on to chapter 70 and hopefully people brought that with them. I did bring my 70. I will tell you, I did not bring 71 or 72.
You know what? I think I got 71 and not 70.
No, it said 71, but when I opened it, it was 70. I did, because I did look at 70. I didn't think we'd get this far.
Oh, yeah. it is.
Oh, gosh.
Yeah, so this is the traffic code. And I'm hoping Mr. Mock can find in here the part where it talks about like who gets what percentage of every ticket. But I did ask Mr. Guzman to get that information based on the last committee meeting. Because they were talking about the, you know, the tickets for, trucks don't have the proper covers on them.
I, for that, I know the general, and I'll have to look it up specifically through the statutes, but the general rule is traffic fines go first to all the court fees or costs that are set out by statute. Then it's whoever writes the ticket keeps 100% of the money, except certain tickets like overweight designates, they go to the State Treasury Road Fund. Other tickets designated, it goes to other funds. So it's basically the fallback position is if you're speeding and you're fined $100 and 50 of it's court costs, the other 50 goes to the county if the county wrote you the ticket, or it goes to a municipality if they wrote you the ticket, or it goes to the state if the state police wrote you the ticket.
Okay.
However, what you're dealing with is the state government more and more has decided to not let the locals get so much local funds, and they write into these laws, we're keeping it for this dedicated source. So I'd have to look that up, and Matt mentioned it to me too.
I asked Matt specifically about evading a traffic light, what the, I don't know.
Evading the traffic light should go to the local unit of government.
So that would go to the township or
No,
the
never the township.
group that.
It's
wrote
who
the
wrote
ticket?
the ticket.
So it would be Will County.
Well, if
they
it's the
wrote the
county
ticket.
sheriff.
Yeah.
But you could write, yeah, technically a municipality is not supposed to write on an unincorporated township road, but they do write tickets on incorporated township roads because some of the township roads go through
I mean, it's Pelican.
municipality, and municipalities are supposed to take them, but they don't always.
Mhm.
By operational law, they're supposed to take them, but sometimes they won't.
Well, this is an unincorporated
Yeah.
subdivision, so they should definitely get the money.
It would
but
go to the county then.
I was told they don't get the money, so
Eh,
I have some insight.
Yeah.
please.
So when I worked in the police department, one of my jobs was to make sure where the funds went. If they write it on a state charge, the money goes to the state and about 13% goes back to whoever wrote the ticket. Most departments, what they do is they adopt these state laws locally and then 100% goes back locally.
That's why they use administrative rules.
Yeah, so the officer was right. He probably doesn't get any, if he writes it as a state charge for that one.
Well, we need to find a way to make that a
We are.
county charge.
right here.
We're here.
It's right
That's-
here.
Yeah,
This is what
that's,
we're doing right now.
that's why I wanted to bring it up because I
We
knew.
already do have that though, in one of these provisions.
Okay, well. you
We
can
adopt-
For me, Phil.
Yeah, one of them, let me look. We're not there yet, but
Yeah, no, that's okay.
under chapter 76, we've adopted the Illinois Vehicle Code.
We're not on 76.
No,
yet.
but I'm just letting you know, it's a one-page thing, but
Oh,
we'll let you know, we've already adopted it. So we have the ability to write local ordinances for anything we want. That's under the traffic code, which is chapter 11 of the traffic code, because there's other provisions like no driver's license. You can't do that individually. That's got to be a state statute. But
you know what I'm looking for. I
No,
want
but
us
I
to
know
be
what
able
you're
to
sa-
keep the
I-
money for writing a ticket in a
Right,
unincorporated
right.
subdivision or road.
and I got to defer to Member Logan. I'm dating myself. When I first started, we kept 100%, but they did state to change the statute a long time ago to
Let's
give
fix
lower
these.
percentages.
I want to give us 100% of this one. Member Newquist,
How about overweight trucks?
we get to keep that. I
We get to
believe.
keep that. Then I, as a matter of principle, would like to see us way bump up these fines for overweight trucks.
I know,
You
I don't.
can't.
Why,
We
You
can't?
can't.
oh,
Why?
The state sets the fines for the overweight
Oh,
truck.
The
that's a
state
bummer.
needs to get on with it. They need money.
They do need to get on with it.
And again, you only get to keep them on county roads.
Yeah, that's okay.
I mean, the thing is, we have so many trucks going through areas where there should not be
They go up and
semis.
down Bluff Road all the
And,
time.
You know, or
in that
through
street up.
neighborhoods, or they bypass, and it's like, I would love to see us really hit these
So I have
guys.
some
Oh,
insight on
go
that.
ahead.
Fines that matter.
So to your point, the only people that can write trucks are truck enforcement officers.
Yeah, we have a
only
whole
we have
unit.
two,
I
right?
think we only have like a handful of them.
Like
They have a whole.
5, yeah.
Five.
Some
Oh, we have
equipment,
5
everything.
now?
I
Okay.
saw them one day at the Chick-fil-A in Bolingbrook.
We used to have two a couple of years ago, so I think we must have bumped up.
Yeah.
Can we find out? Who do we?
I can call a sheriff.
Chuck, find out how many overweight truck unit enforcement people we have?
And we still have portable scales we
Yeah,
use.
that's what they use, the portable stuff.
Well, they don't have to. They can drive them to a real scale. They're just so
So-
real scale.
So we have two scales.
Mhm.
In my public health and safety, I've already addressed this. And we tried to even maybe suggest that they get a couple more scales because there seems to be
We
a
have
need
lot of
for it,
roads, yeah.
mostly on the east side of the county.
Mhm.
And obviously, she's speaking about the same thing I am. They have a lot of problem with people coming from Indiana and cutting through. A problem is, they only have the two scales and they got the whole county to go around.
So maybe this needs to be our suggestion, because I think it's just a suggestion unless we appropriate the money and tell them this is what you have to use it for. Because otherwise, I think they just manage that money and that equipment on themselves. I seem to recall them coming to the finance committee asking to spend overweight truck money on something. I've been here a long time, so don't ask me what it was on, but they did, they did do that. Because they do collect, and it stays in a separate fund, if I recall correctly, and Mr. Mock is shaking his head, so it does. And I don't know whether they used it for new trucks or new cars or, balloons. I mean, I just don't remember. Member Freeman, you had a question?
I do. So the fees for overweight, I know that they have to pay, but these seem awfully low.
Yeah, the state sets them.
The state sets, that was my
We
next
can't
question.
change it.
So the state sets those?
Right. Usually what happens, so the truckers are individually responsible, but their companies usually pay it. And it's to them just the cost of doing business.
Right.
If they get caught, they run 100 trucks that don't get caught, the 101st gets caught. They just pay the fee
Move along.
and move along.
That was all I had.
If
Thank
you want to, text or email your state senator, state rep, let them know they need to increase these fees because Illinois is going broke. Here's an excellent way to collect more money, get it from people who are violating the law.
And there are good ways around it. When they know they're overweight, they can get special permits.
Yeah, we have ox cart.
Yeah.
I know they do bigger loads or wider loads or.
They do
whatever.
wider, they do over length, but they also do overweight.
Overweight,
If
yeah.
there's a
It was,
certain,
it was not the fines. This is for the permits.
right.
The permit seems 50
Oh.
bucks for a single trip.
Oh, well, I don't know. I can only say at the township, we had people call us several times about stuff they wanted to bring up and down New Avenue or Smith Road. And I always had to refer them to Lamont because Lamont adopted those roads. But I just know there was no mention of our ox cart system in here. It mentioned that they had to apply, but it didn't say how or anything. And I just kind of wondered if we should have that in there. Maybe not. I don't know.
They have changed over the years, the systems.
Okay, well, it's been ox cart for a long time now.
And-
Maybe not the whole 17 years.
I do know there's like a program or something. They, like, this is my path and the program will let them know
Yeah.
who has to have permits along the way. So-
Yeah, but it must not get updated very often, or maybe you have to apply for an update or pay for an update because, like I said, people called DuPage Township for stuff that was clearly Lamont. Just because they had adopted the roads. Was
Ma-
there any other questions in chapter 70?
I'm just kind of bummed that we can't really do anything.
Yeah. I don't really want to.
Now, so if you look at page 12, based on a recommendation of the sheriff and the fact that it's legal in 7099, they did ask me to increase the proposed penalties under A1 to 500 instead of 100. When we originally wrote, and it's on page 12 of,
Yeah, I see it.
I did raise some of the fines that they thought was appropriate to raise.
Can you, how do I say this? Doesn't that normally have to come to like the finance committee?
I don't know.
Okay,
You're
were there
right. In
any
the
other-
ordinances, I put it in there. No, that was the only one I think in this one.
Well, I would agree, $25 to $100, that's not nearly enough for an abandoned vehicle. Although I gotta imagine if they filed off the VIN number, you wouldn't even know who to collect it from.
But I did, so you know, when they did recommend to me that we need to bump it, if we're legally we could, I would. And I did.
And that was the only one.
That was the only one I found in this section that they asked about. But that penalty applies to a lot of the stuff.
I see what Member Freeman said about the cost of these things. I guess they maybe make it low in hopes that people will actually,
Right, they really want them to have the permits
yeah.
because it's a control factor.
So in construction, a lot of your heavy equipment operators who require low boys will have to pay those $50 ticket or fee just to transfer their machine to a job and then back. And so if they're doing 100 jobs a year, starts getting pretty costly.
Didn't realize I turned myself.
Put them out of business.
And the other one it affected why they kept it low is farmers.
Yeah.
When
'cause
they're
they-
hauling grain,
Yeah,
it's always overweight.
right, and this time of year, they're doing a lot of grain hauling. Member Freeman, did you have a question?
No, that's my light. I don't mean to
Okay.
turn it off.
No, it's fine. All right. Do we want to move chapter 70?
I just,
Yep,
can I ask a quick follow-up?
yep,
question?
please.
So Phil, there's really nothing, I mean, this is all per state statute, correct?
And
And this
Except
is
for-
another one that we usually keep current with.
Yeah,
Yeah,
okay, so except other than boosting up the fine to 500, we don't really have any discretion on any of this for the most part.
pretty much.
Okay.
So I would just entertain a motion to move this one forward to exec.
Motion to move this.
Second
chapter
Freeman.
7
Motion
to-
by Newquist, second by Freeman. Roll call, please.
Logan, Butler, Freeman,
Yes.
Newquist,
Yes.
Richmond, Trainier.
Yes.
Motion.
Carries. The next chapter would be 71, but I think we had a technical error in the
Yeah, I don't
printing.
have it.
Because we don't have 71 printed, and I will be honest, I was too lazy to get my iPad out and look at it, so we can go to
I
72.
thought this was 71.
It's only 2 pages.
Oh, I didn't.
It's
I was
no
too lazy to
routes.
Go find the iPad. If you want to make a motion, if you've got questions, you want to make a motion to move it forward, I'm good. I just don't have a copy of it.
The only change I made to it was I put the term superintendent highways also mean county engineer
Okay.
from what we currently have. And it basically just gives us the ability to set out our snow routes and require people not to park when we're plowing.
I'm not even sure if 71 was on our agenda.
Yeah, it's on there.
Okay, like I said, I didn't go get my iPad. I just was looking at what I had paper copies of.
Well, this said 71.
I know, and I
just-
noticed it was 70.
I just read through it. Next
Yeah.
time.
That was terrible.
No, it's okay. I noticed, but like our, oh, look at there. You're a doll. Thank you. Yeah, anything? Okay, make a motion and we'll move 71 forward.
Thank you.
Motion by Logan, second by Butler. Can we get a previous roll?
Previous Newquist.
Previous Newquist, second Richmond, all in favor? Those opposed? Motion carries. Now we're on to chapter 72. Look at us flying, you guys. It's only 10 after 11. I love it. And although I know we still have questions on the stormwater thing, and we'll get those answered in executive. Chuck will drag somebody here if necessary. Now, Mr. Mock, do you want to talk about this? Because man, oh man, is this a lot of red and,
The reason it's a lot of red is because the highway department asked me to put it in this format instead of the old format. Because that's how they use it. We had it in the box system and they wanted it. They're the ones that sent it to me and I just blocked and printed what they put.
okay,
I found unusual that if you notice, if you just look at page 1, where it says date,
yeah.
but they have dates for some and not others. They didn't have an explanation why they didn't know when they were passed. It might have been so old that it was before
The
they
road
kept
was there,
dates.
mother was a baby.
But the only thing this is doing is basically changing it from the boxed system to the modern system that sets the load limits, speed limits, and truck routes. It's three areas, and all 3 of these are currently what we do.
Okay,
And what will happen now is when they decide to add a new truck route or something,
Mhm.
like you discussed about a dedicated truck route for the landfill,
mhm.
I'll make sure that we update our ordinance, not just do it as a separate bill, because that's how we always used to do it.
Right, that's what we said we were gonna do. You know, maybe I'm not getting there yet. I'm looking at the speed limit and the weight limit, but I don't remember seeing the route limit.
Okay,
Maybe I got.
hold on, I'll find it.
Yeah, all I saw was speed limits, yeah. Maybe there's a route here somewhere. Particular one didn't have the resolution in the front of it. Maybe you guys didn't expect us to get this far.
I probably didn't, but I did send resolutions over. In order to get them on the
Here's
county
the
board
truck route.
agenda, they had to be there.
It's on the very back page. Okay.
Yeah.
So the very back page, 42,
Last one.
and there's so few of them that there's only 3.
We had a lot more crossed out.
Well,
Well, the ones
that's-
crossed out were because
that's the speed- the speed.
they're no longer designated by us, they're by the state
Oh, Weber Road is designated by the state now?
as a truck.
Okay. Didn't realize that. Lorenzo Road too, okay. So the only, yes, go ahead, Leader Williams.
County Highway 10, where is that? The other ones say where they're at, but this one doesn't on the first page.
I don't know what County Highway 10 is.
I had to go look up some of these.
There's a map that has it, but I don't know where it is.
Long time to figure out 88 was Weber Road.
Well, the rest of them say,
Well,
Yeah.
the
Only
rest of them though are only parts of County Highway 6 and parts of County Highway 5.
See if somewhere else.
And I see a typo on page 1.
Oh,
How did I miss that?
well, fix that, please.
Sorry, if you look under load limits, if you go down 1, 2, 3, 4, County Highway 5, it says Canton Farm Road instead of Caden.
Oh, yeah,
But that was how it already was. I
Yeah.
didn't catch it when I did it. I'll knock that out.
okay.
And it's a Scribner's. I don't need an amendment. I just wanted to
No.
let you know I'll move it forward with that changed.
Thank you. How do we have one of those maps here somewhere? I know I have one at home that would show us all the highways. We probably ought to have one of those here somewhere, just.
You
FYI.
should, but I know they got them on the highway. That's where I've always had I drive out to
I
look
have
at
one
them.
that's just for my district, but.
I just looked it up and it says it runs north-south along Will Center Road and the route stretches between Crete-Monee Road up to the Kankakee-Will County line. That's Highway 10.
Highway 10's the county line road,
Says it's the
basically.
Eastern.
Yeah.
Is it called County Line or is it called Willow Center?
It says Will County Highway 10.
10.
Oh, I
County Road
see.
10 is in here.
There. Yeah,
Can you repeat that again?
It runs north-south along Will Center Road
Yeah, it's Will Center Road, basically.
and it stretches from Crete-Monee Road up to Kankakee-Will County line.
Yeah,
I was gonna say, I think it's in the middle of either Will Township or Green Garden Township.
but it's Will
Yeah,
Center.
pulling up a map now, so.
So it must
Okay.
be Will Township.
Okay.
Hmm.
Anything else, you guys? And I don't know if you want to add that in there, Phil?
We can add it.
I would call that a scrivener's error too, just didn't
Yeah, I
have
can.
the description. Yes.
I
Member
found County
Freeman.
Highway 10 Will Center Road on page 33.
Ah, okay, see, I knew it had
All
to
right.
be here somewhere.
So I say Will Center Road.
I was looking.
It's like halfway down the page.
And I apologize, but that was another one where it was that way to begin with and I didn't update it or catch it.
You said page 33?
Page 33,
Starts at Creek Mountain Road.
Creek Pony to 2,640 feet
Yep, there
south.
it is. That's how I found Weber Road was Highway 88. I went and looked at the alphabetical list. Yeah. Okay, very good. All right, there's, yeah,
I just
go
have-
ahead, Member Newquist.
So I know we can't, if the truck route is set by the state, I know we don't want it in our ordinances, but do we need a list somewhere of truck routes going through the county?
Well, here's your biggest problem with that. Under the federal code, we have an interstate highway system. We have a federal highway system, like Route 6, Route 30, Route 52. The federal government, in their rules and regulations for those roadways, the interstates and the US highways, say trucks get to travel
Anywhere.
a certain mile and a half or 5,
Yeah.
there's certain amounts
Oh, past the
That
that
route.
they get to travel off of those roads on
Mm.
anything they want to travel on.
So it literally makes almost anything a truck route.
It almost makes anything truck eligible.
Okay.
Because
Which
I,
is why it's important when they go to do planning and zoning for building these warehouses and everything, that they're in a place where
which
they're
falls
close
within
enough
that
to a
area.
truck route and they're not gonna drive through a residential area, which I know they've done that. I want to say somewhere along 53, and I think that's why they closed that one road.
It might be. You know, they have closed halves of one road, made it accessible only one way because of that.
Mhm. Yep. Yeah, we've done some strange
But
things.
no, I ran into that problem years ago trying to enforce truck tickets on Route 53. In fact, it was. And the lawyers on the other side pulled out the federal statutes and they were right. There was nothing we could do about it. And I had to bring it back to the county board and let them know back then. Nobody was happy with it, but it was just federal supremacy because of interstate transportation.
Mm-hmm.
They basically, if you're close to a main road, you get to travel to and from it. Originally, it was only for gasoline and food. Then they later changed it to also your truck terminal. That's what caused all these truck terminals.
Interesting. Okay, if there are no further suggestions, oops, there we go.
But
Member
they
Buck-
still have, even though they get the 5 mile limit, they still have to adhere to road weights, correct?
What do you mean?
So you might be able to go off a truck route for 5 or whatever miles, but if you're too heavy for that road, you could still be ticketed. So if they get on a residential road and they're way heavy and they get pulled over,
No,
they could be ticketed.
If the residential road is a frolic, yeah, they can be ticketed. But if they have to use that residential road to get to their warehouse, they're allowed to be overweight. They're allowed to be
The same
the
way.
weight, same weight as on the interstate.
But like for the people that bypass 80 and they come through Crete, if their trucks are too heavy,
If they're
obviously,
bypassing 80, like for a shortcut to get to another roadway,
if they're
then
too
they're
heavy-
overweight and they can be ticketed.
Right.
But if their terminal hub, if it's the Amazon warehouse off of Route 57 and it's down a road that's, say, a mile down the road, they get to be overweight on that mile of that
Right.
road because they're going to their terminal.
Right.
But if they're just cutting through as a shortcut from one highway to another, they can be ticketed.
Yep. Okay, if we're good with 72. I'll take a motion to move 72 forward to executive.
Motion Freeman.
Second Newquist.
Motion Freeman, second Newquist,
Previous role.
previous Butler,
Second Logan.
second Logan. All those in favor?
Aye.
Those opposed? Motion carries, and we are on to chapter 73, which will probably go just as quickly because this is about prohibited parking places.
And
And I don't know how much it changed.
it's what you currently have. Nobody came forward and said they consider any more prohibited
They
parking.
used to have a lot more and now they have less. So I think this Bluff Road must be a different one. They're calling it County Highway 77. I don't think you could park anywhere on Weber Road, so that's just interesting that they only have it between Division and Root Street.
They probably, when that was originally passed, Weber Road wasn't 4-lane.
Yeah, it
There's no parking in and out because there's no parking lanes.
Right. Are
But
there
why don't,
parking lanes between Division and Root?
no, but there used to be between Division and Route
Uh-huh.
was farm fields. There were no curbs. Now it has curb and gutters. And the reason they put that in between Division and Route was the prison. They didn't want the prison escapees to have people having their
Waiting for
cars,
them on the car.
waiting for them parked on that road.
That is funny. Well, there's supposedly not too many people in the prison these days.
But that's why that was originally picked.
Do we still need that though? I mean, I guess, maybe?
You could strike it if you want, but nobody's ever complained, why do you have it?
No. Nobody would ever park on Weber anywhere.
Well, they
There's
can't.
this-
They can't because there's no shoulder.
Well,
You could.
oh, you could pull up over the curb, but I just don't see anybody doing that. Mm-mm.
And if you wanted to change it to say all of Weber Road, you could do that too. But is it really necessary because of how the road's set up?
Mm-mm. Can you imagine parking over on the interchange over the top of 55?
You could park down by like 30, there's the Isley, the Boulevard. You could park on the Boulevard, it's legal to park. Yeah, I don't know.
Go ahead, Member Newquist.
Yeah, like I'm a little confused because I'm looking at County Highway 74 Laraway Road.
Mhm.
I mean, you can't park anywhere on Laraway Road, but this is only no parking from Center Road to 500 feet to the east of Center Road.
know,
But
it
that's
seems
because
weird.
that was passed in 96 and Laraway's been rebuilt in 4 lanes since that time.
So I mean, is it a given that you can't park on a 4-lane highway or do we need
You
to?
can't park on any highway. Parking is to pull off of the road to park.
Well, all of these are highways, so
These are all
that's
highways, yeah. Crete-Monee Road.
No, no. They're all highways, but county highways doesn't mean the same thing as
highway.
a
Right.
highway.
Okay.
It is, if you have a rural cross section like what Briggs Street is, a rural cross section consists of no curb, no gutter. You have a area and then a ditch along the side of the road for drainage. Those are where people could pull over and park their cars. People with flat tires would pull over there and change their tires.
So you could park in the drainage ditch or?
Well, it's wide enough before you get to the
Yeah,
drainage ditch.
Or like on Crete-Monee Road, there's farm fields you
Right,
could
right,
probably
right.
potentially pull over.
And again, the most recent no parking was Briggs Street in 2023. And that's
There's curb and gutter on Weber between Division and,
now there is,
yeah.
but there didn't used to be.
So basically, this is working. Nobody's complaining
Right,
about.
I asked the
people
highway, do you
parking
need
the-
more? And they said no.
Okay,
Yeah, there is no parking spaces and you'd have to drive over the curb. I mean, if they're okay with it, I guess we can just leave it. I
And
mean,
again, you can always add more later.
they're not gonna write a ticket because nobody's gonna drive over the top of the curb. I guess. I mean, I wouldn't want to.
I've seen people do it.
I mean, I can't say I never have, but yeah.
You need a big truck to do it.
Oh, no, I've done it in my Chevy Bolt. Yeah, in the township parking lot, when we were out of spaces, I would just pull up on the grass. Probably wasn't the nicest thing I ever did to my car, but
all right, you want me to make a
Fine.
motion to move this?
yes, please.
Make a motion to move to executive?
Second Freeman.
Motion by Newquist, second by Freeman. Previous?
Previous Logan.
Thank you. Can I get a second? Second Butler, all those in favor?
Aye.
Motion, all those opposed? Motion carries. All right, we are on chapter 74, which by the way is my last, do I have a 75? Oh, no, I have a 77. We're not done yet. I got a 74.
60s?
Parking regulations.
I don't know why.
This just gives us the power to regulate parking on any county-owned property, roads and et cetera, parking facilities.
Wait, why did we skip from 50s to 70s in our chapter numbering?
Because when American Publishing first set it up, they went with odd numbers. So if you ever wanted to fill
Oh,
in
right.
whole new areas,
Three,
you'd stick them in,
fives,
you'd
right,
slide
I
them into
forgot.
even ones.
Okay,
Okay,
So it goes Article 1, 3, 5, 7.
which I should have
The
realized.
one example though,
Better.
when we did Article 3, there were so many 30s, we went to 40 eventually.
Right, got it. That's what threw me off the going to 40.
I mean, this just talks about fire stations, fire hydrants.
I mean,
And so, you know, it's basically, we passed this and I don't know why, because we did adopt the whole highway code. But a lot of the parking regulations are in the traffic code in the 11s. But I think we did this before we adopted the whole thing. To tell you the truth.
So do we actually need this?
No, you don't really, but I would keep it only because you've already had it. People are used to it. If somebody wanted to worry about a parking thing, they could look it up online and see it here.
Well, I didn't have any issues with anything
I-
that was in it. I didn't even have any questions. Although
Now,
you're exempt.
if you look
detail or
at-
device,
if you look at-
odd.
question about pedestrian.
If you look
go
at page 8,
Mm-hmm.
under 7418, we may want to keep this because it does have something that's not in statute. Because of the Chicago versus Hertz case, it says it's prima facie that the owner is the illegal parker.
Okay.
That's
Even
based
if-
on case law, not on statute.
Right, even
so
if
us-
somebody else drove the vehicle, it's
Right,
the
you're
owner.
responsible because it's your car.
Yep.
Where was this?
On page
Page 8.
8,
74.8.
74.18.
The prima facie.
Yep,
evidence?
that's
Yeah.
it.
We adopted it, but it's really based on a court case.
Normally you don't put in there.
Wait, what page
Right.
is this?
Page 8.
Page
Okay.
8.
Can I,
And we did increase one of the fines for handicap up to 600 to match state law.
Okay. Member Freeman?
so I think you're gonna say it's state law is the reason that you on page 6, section D on 7411, you struck out the local authorities shall impose fines
Right.
for people parked in handicap. Is that because of state law?
That's because it's state law.
Okay, thank you.
Anything else? I'll take a motion.
Motion Newquist.
Second, Freeman.
Previous Logan's second.
Motion by Newquist, second by Freeman, previous by Logan and Butler. All those in favor say aye.
Aye.
Those opposed, same sign. Motion carries. We are on chapter 75.
You know, this is one of those two where I'm completely unqualified, but, you know,
I looked at it, it's funny, the other day I see, and I don't know if we have e-bikes in here, but I seen a dude riding an e-bike down the street and he had a passenger who was literally standing up behind him
Jesus.
on the e-bike on a residential street, and I was just like, holy crap.
And they go so fast.
Yeah, do we have anything in here about e-bikes?
we do. Well, the up 75.18, riding on motorized pedal cycles.
Oh, there it is, sure enough.
Yep.
I was looking for the word e-bike. Okay, so this would also count like, what do they call them, limes? Scooters, electric scooters?
Yes.
That's a good question.
There's no pedals per se, but member Richmond is speaking up. Go, sir.
So this is something that Phil and I have had a conversation. Oh, is this a good time to bring that part up?
I think it's the
Okay.
perfect time. I was going to
Right.
suggest it.
Yeah, so, and on my way here on Route 30, there was somebody on one of those scooters.
Hmm?
in the middle of in a lane.
I've seen wheelchairs, but okay.
But, but we were talking about what they call these low-speed vehicles,
Mm-hmm,
which is nothing more than a golf cart
mm-hmm.
with seat belts and a windshield. And I mean, it's out of control.
People are out of control.
I mean, it's, what we need to do is look at, I mean, I know Phil and I have talked, the state does have some, guidelines or whatever you want to call it, Phil, on this. But I think it's gonna be not only for the county, but also for the townships and the villages to where, it's just gonna take one of these incidents where, I mean, you're required to have a driver's license and seatbelts. I saw a lady with a child in a child seat. I don't know if it was buckled in or not, but on one of these things, I mean, driving one of these things. I don't know, to me, it seems like a recipe for a disaster at some
Was
point
it
in
like,
time.
a bicycle seat? You know what I mean? For where you add the kid?
Bucket.
Yeah.
Wow, a real
Yeah,
car
car seat.
seat, a
Yeah.
real car seat.
A real car seat. I'm assuming that it was buckled in to some degree, but
Had to be.
I don't know, you never know. But I guess I'm just, from that perspective, I'm concerned about our rural areas, our townships. I know that farmers have, they've got that orange triangle and they're out there with their low-speed vehicles, which are tractors, things, gators, or they call them and that kind of
Yeah.
stuff. But I think it's something that we need to maybe take a little bit of a deeper dive at these things and see what we can or can't do to protect, it's gonna happen. It's gonna be car versus golf cart.
Yeah. Do you have any suggestions, Mr. Mel?
Well, I have questions
Okay.
because it's policy.
Mm-hmm.
We could set this over. We could rewrite and add low-speed vehicles. However, I don't think nobody's really using a low-speed vehicle. A low-speed vehicle is a term of art. It's a term of art only for vehicles that have a minimum speed of 20 and a maximum speed of 25. So a golf cart wouldn't apply. They also have to have special license plates issued by the Secretary of State and all this other safety equipment. They're basically a small electric car that has no power. That's what a low-speed vehicle is. Well, most of these people are operating on the roads are golf carts, or they're souped-up golf carts that go faster than 25 miles an hour, which would take them out of the low-speed vehicle requirement. There's something we can do.
Mm-hmm.
I don't know if it's a problem on county roads as much as municipal or township, but the county can ban low speed vehicles from county roads.
Okay, well, let's do that.
Municipalities can ban them from municipal roads, townships can ban them from township roads.
I mean, let's do that. It's
but
at least something.
Yeah, so I guess the only thing that's in the back of my infill too is when I heard the Forest Preserve saying that they had, in DuPage County, you could have an E2, and when they come across our Forest Preserve, it's an E1 bike or something like that, which is 20 miles an hour versus 10, I don't know. I'd have to go back and look at the notes, but
Is this
to where-
supposed to drive in the Forest Preserve?
to drive on the trails or those e-bikes.
Oh.
And remember, they were talking about how it's legal up on DuPage, but not in Will County, and the trails all interconnect.
Mm-hmm.
So then it puts our officers in a bad position where I hopped on in DuPage and I came down here and now I'm illegal and now I'm getting a ticket.
Yeah,
Wow.
but that's no different than saying,
Yeah,
Cook
but-
County's got a 50-mile-an-hour speed limit and I cross over County Line
It's
Road, it's down to
35.
30 and I'm not gonna stop.
Yeah,
I know, I'm just trying to think
outside of the
the
box.
bigger
yeah.
picture here. What are we looking at? Because you're right, all these are our golf carts with a seatbelt and a windshield and. maybe a-
But again, if they're just golf carts, they're banned totally.
Yeah,
But a friend of mine who retired and just bought a golf cart actually it was able to get license plates from the
Then it's-
DMV.
that's why
is
they're called low-speed
probably
vehicles
then-
now.
Yeah,
It probably only has a top speed of 25.
Probably roughly, but he drives it all over.
But
It's
again,
hilarious.
that's something though, if we didn't want them on our county highways, we could ban them. That's a policy decision.
Mhm.
I think we should.
They're kind of a
I mean, it sounds
hazard
like
on
that's
a-
what
on
you
a-
guys would like to do, so.
I mean, in a municipal area on the side streets, who cares? But I agree on the
Municipality
highway,
might.
on the highway count, on the county highways.
Yeah, they shouldn't.
I
be
could
there.
see where they could be a potential hazard
Yeah.
for sure.
I think,
Yeah.
go ahead.
So I worked for another police department that we would register golf carts. We'd register close to 50 or 60 of them. And they couldn't drive on county roads. They have to cross perpendicular and everything.
And,
We
and there
had-
are weird rules.
There's
There's
a lot of-
speed
there's
limit's
a lot
over
of
30,
weird
you
rules.
can't drive on it.
Yep.
If it crosses a certain
It's got to be
highway that,
perpendicular.
right, if you cross it and the highway you're crossing has a certain speed, you can't go against
Can't
it.
cross
There
it,
are a lot
yeah.
of state
Can't go on
statutes.
sidewalks. But
Yeah.
the issue I was getting to is we had a lot of accidents with them. Because as soon as they go to the bar and they hop in the cars and then they drive home in those, so they think it's a free pass that they're not gonna get a DUI. So
And,
that's the issue I got.
and they are, so you know, the e-bike, the low-speed vehicles are a vehicle. They fall under the definition of vehicle, a DUI applies. In Illinois, if you're riding a farm animal, if you're on a horse, it can be a DUI.
That's an OUI.
Yeah, but it is there.
What's the O for? Operation.
Yeah, but it is
Okay.
in the state law.
Well, it sounds like you guys would like him to put something in here about low-speed vehicles.
You want to table it till next month and I'll get
Yeah.
back to you?
Yeah.
And I'll talk to the sheriff and stuff too, and we'll try to come up with some language.
Can I get a motion to table till next month or postpone to next month?
Motion to postpone chapter 75 to December.
Second, Newquist.
Previous loading.
Yeah.
All those in favor
Aye.
and those opposed, same, and motion carries. So we're gonna postpone 75 to next month. 77 is completely gone unless I'm confused.
I got a 76.
Yeah, so I can just, do we have to
No,
do
77,
something about 77? Is
I
like-
want to talk about
I
it.
don't have a 76. That's weird.
76 is just traffic and vehicle registration
I didn't read
regulations, one
76.
page.
Yeah, I don't have 76. I mean, it's on the agenda. Yeah, I don't have it in my,
I'll find it.
I got it. It's all right.
So I like my book to be
I
complete.
got
I
this.
don't have 76.
Okay, I can tell you what it says. It's adoption of the Illinois Vehicle Code.
76 is a powerful ordinance.
Right. It basically allows us to adopt the entire
That's
vehicle
it. It's
code.
one paragraph.
Oh, wow.
So then, Phil, how would they write the ticket? Because it says you put 76 in front of it. Like, would a DUI be 76-11-501A?
Right.
Really? Okay.
That's exactly what they do. Because
And then we get 100% of that. Well, not DUIs, but certain things we do.
certain things you do.
Okay.
And the sheriff,
He knows.
the
Yeah.
sheriff has the ability to do it. And again, these are for going to court, not administrative adjudications of separate things. But this, you can still take them to court as a local ordinance.
Correct. 76 is good. I like it.
Yep.
And I don't know if that was issued to us by the state or where it came from, but it's been that way for a while.
Motion Newquist to move
I
forward.
literally just read it. It's, you want to see hers?
To move 76? No, I'll go with whatever you said.
76 is 2 paragraphs.
Yeah, it's
Right there.
literally,
There, 76 is up on board. That's it.
Yeah, no, I'm just gonna print it when I get home because I really like I like to have everything in my final book. So
Phil, I got a
motion,
question. I'm sorry, I got one
No, it's
question.
it's like you
Not
get
more than
rid of stuff
1,000. There
when
are
you're done with
penalties
it.
in the IVC, more than $1,000.
There are, we could make it higher, but
So I know there's one.
On
like
our purpose,
2,500.
on our purpose, it was just, it originally said just fine them $45 for everything.
I lose 75.
And I said not less than 45 as a minimum and not more than 1,000.
Okay.
We could make it,
No, that's fine.
we could make it up to 2,500 because that's a petty
That's
offense.
petty offense.
Put in there or higher where allowable or something like that.
Yeah.
No, you'd
And
rather.
it's
clean-
hard to do.
All right. Okay.
But no, if you think it should be more than 1,000, we can make it more than 1,000. You can go, by law, you can go to
2,500.
2,500.
Yeah.
Yeah, make it 2,500. Why not?
All right.
We do
We
that?
don't have
Sure.
to charge
So
somebody.
Because that's something I
Can
just
make
threw,
a
I just
motion, or can you do that? Can I make a motion to make it
Right there.
2,500?
make a motion to
See.
amend it to 2,500.
Yep, any person.
And that was for 76?
Yeah, at the very bottom, she's.
99 under penalty.
You scroll down just a
Just a little
little bit.
bit, Jackie?
Yeah, there you go.
Okay,
So this is basically saying our fines are gonna be a minimum of 45 and a maximum of
1,000.
2,500.
And we can make them-
change it.
You can make the not less than more than 45 if you want.
45's fine. Like a no front plate, $45, that's fine.
Right.
Okay, and not more than 2,500?
I think we should.
That's
go
your
with
motion?
500.
That would be
Do
it.
we have a second?
Second,
Second, Leader Richmond,
previous roll.
previous roll, Newquist, second Freeman, all in favor?
Aye.
Those
Aye.
opposed, same sign. And now to move 76 forward to executive committee as amended.
Motion Newquist.
Motion Newquist,
Second level.
second Logan,
Previous Richmond.
previous Richmond,
Second. Freeman.
second Freeman, all in favor?
Aye.
Those opposed, same sign, motion carries. So 76 is going forward to exec with the amendment. And now 77 is just deleted, so you don't
Right.
need.
I wanted to talk about it though.
Yeah,
Yeah.
please.
The reason 77 was deleted. 77 was passed originally when, as part of the towing regulations. When we went to administrative adjudication, all our towing tickets get handled through our administrative adjudication process.
Right.
This came first.
Okay,
They quit using this procedure when they went to the other procedure. The other procedure has the safeguards of this procedure. The reason I wanted it stricken is we don't need to, they don't use this one. But I just wanted everybody to know why I thought we should get rid of it because it's covered elsewhere.
Okay.
great, it's covered elsewhere, I like that. Oh, I got it just in.
Do we need to make a motion to get rid of it or does?
No, that's what I was asking.
Well, you should move to repeal.
Move to repeal Freeman.
Second Newquist.
Previous Richmond.
Second Logan.
Move to repeal by Newquist, second by Freeman, previous by Richmond, second by Logan. Thank you.
And then move it
All in
forward to
favor?
have them repeal it.
Yeah, and move it forward to and include move it forward so the executive committee can also vote to repeal it. All in favor, say aye.
Aye.
Those opposed, same sign.
77.
Okay,
Gonna be
all right,
I already
look
said
at us go.
Okay.
And we're on our last one, chapter 78. I'm gonna get out of here in time to make it to Rotary today. I love you guys. Thank you, thank you. And if you want to talk about 78 for a long time, I'm gonna say, let's make a motion to
I just
adjourn.
have one, that's all. I got one.
Okay, Mr. Logan, please.
The only point I have is 78.20. Can we raise that fine to 500?
You could,
Okay. Can
you
we do
chose
that?
the fee, it can be, I do not think it,
Can I say
Sure.
something?
Where is this at?
There was a big issue about this a while back, maybe 2, 3, 4 years.
That was like 10 years.
No. It was fairly recent after the new courthouse was built because of the parking situation there. Sometimes, people were parking in the wrong place.
This is for admin tows, right, Phil?
right?
This is an
Oh.
admin tow. This is like a traffic offense.
Oh,
This is like DUI.
so I got a DUI or I didn't have my driver's license or insurance and you're telling me
No.
oh, just a
Where
DUI.
is this at, Vince?
This is 78.20 fee
Page one?
schedule, page 1.
203. I'm on.
Yeah, we instituted,
one.
my last department, we instituted a $500. This is someone who gets arrested for DUI, registration is
Oh,
suspended.
fee schedule,
license
78.2.
suspended.
If you look
Slightly
under,
misdemeanor.
look at
Serious.
page 2, and it lists all the things that it applies to.
Okay.
Yeah. Applicability under 7830.
Operation, driving under the influence.
The car shouldn't be on the road, basically.
So are we changing that?
Most
from
departments are
300?
500. Some are going to 750, some are going to 1,000.
Okay, I could go okay to 500 if people are operating it.
So keep in mind, this goes to a court in front of an adjudication. The adjudication officer hears it. If the person can't pay, sometimes they make exceptions. So just so you know, it's not just like a $500 and we're gonna keep your car forever.
Okay,
That's why we have adjudicated hearings.
so
And
you're
it-
telling me that in order to get your car back, you don't have to pay the $500 fine first?
Yes,
No.
but you can get your money back.
Yeah, you can.
I,
You go to administrative hearing,
You
and-
could plead and get your money back.
Well, it's not quickly. It's within a month. It's before 45 days.
Okay. Member Newquist had a question.
Yeah, number G, operation or letter G on page 2, operation or use of a motor vehicle while soliciting, possessing or attempting to solicit or possess cannabis. Is it illegal to possess cannabis in your car? I'm assuming not.
Though, because
But
you
you
buy
gotta
it
read
at
it
the
further.
store.
Yeah, it's.
As defined by the Cannabis Control Act.
Act.
So-
The Cannabis
Okay.
Control Act
Okay,
carves out the exemption for medical or
recreational.
recreational or whatever. If it's not a violation of the Cannabis Control Act, which has to be a lot higher weight than what it used to be
Right.
any amount.
Yeah, if
That's
you've got a trunk full of pot, you
right,
know,
that's
you're-
what you lose it for.
Got it, okay.
Yes, Member Freeman.
I'm still stuck on this fee. So, if we change this fee, so my son got in an accident and the police
Accidents
department
that I-
called a tow truck and they had, it's
No,
not the
that's not a
same?
part of this.
Okay,
This is for.
because I'm like, that fee was ridiculous and we would never have chosen
But-
those guys,
But when you read under
Almost true.
applicability, it doesn't say a tow after a wreck.
Right, look through
It's for,
letters A
it's
through
for
M.
all these criminal violations.
If you're gonna commit a crime with your car, if you're operating your car illegally,
If you got a warrant for not showing up for court for driving your car without a license, that
Mhm.
applies.
yeah. Member, Leader Richmond. You have a
Oh,
question?
no, I'm sorry. I'm,
Okay, never mind.
shoot up.
Thank you.
Oh, yeah, I just thought.
No, I appreciate it. I miss plenty.
Big Mike's got a
Member Freeman? Have another
Question?
question?
No, that was it. I'll be real honest, I really didn't read this section because I never dreamt we would get this far.
Yeah, me
I got
neither.
you, don't worry. I got
I'm here today.
But yeah, a lot of
Trying to read through it really fast.
a lot of municipalities have gone to 500 bucks.
Yeah.
I
Trying to get
know
enforcement
that.
group to do it, but they're really reluctant to do it, which I really don't understand why.
And I made some changes, if you'd look at page 4.
Yeah.
We met with the sheriff's office because they knew this was coming up. And the county executive's office, because they're the ones that hired the hearing officer, the administrative hearing officer. And there was a disconnect or an issue that I tried to address on page 4 under paragraph B at the top.
Mhm.
Right now, what the hearing officer does is they make them prove up every case, which means there's 50 of these up at hearing. One person shows up for a hearing, they get their hearing. The next 49, the administrative law judge says, prove your case, even though there's nobody there contesting it. So then they have to swear in a deputy or a person that says, on this day, this happened, this happened, this happened, this happened. Okay, fine, go to the next case. On this day, something happened, something happened, something happened. I changed the language here to have a default, which is no different than you go to traffic court and you don't show up for your ticket.
May I also add, though, in traffic court, if your case gets dismissed because nobody showed up, they have a whole year to bring you back.
No, yeah, but that's not the other issue is the other way, when they don't come.
When they, meaning who?
The defendant doesn't come. If the defendant doesn't show up, it's a default,
Oh, it should be, yes.
and the judge just says, a defaulted judgment, all the proofs are there because the guy didn't come and contest it.
Right.
I put that language in here to save time for our administrative hearings.
They don't have to listen to the officer.
We don't have to have the proof for no reason because nobody's there contesting.
Got you. Okay.
The sheriff asked me to add that. I wanted to let this committee know I put that in here.
Mhm.
I used the default procedures from what court does,
Mhm.
so it's still constitutional and sound. But that was a change that I made based on request of the sheriff,
Gotcha.
and I wanted you to know that.
A lot of
Gotcha.
departments are doing that.
That makes a whole lot of
Does
sense.
does
I-
that apply if if a sheriff or a deputy doesn't show up, I mean?
Well, administrative
Yeah,
hearings,
that's
the
not sheriff's.
administrative
Oh,
hearings.
it's administrative
Yeah.
hearing, so it doesn't matter.
So what
Sorry.
happens is, so you know, they send one deputy to testify
Right.
off reports.
Yep.
Nobody, and if nobody shows up, they win,
Right.
but there's always somebody there.
Yeah, I would think so. All right, so we have this amendment to make it 500. Did we get a second?
Oh, I don't know. Second Butler.
Second Butler,
Previous Nucleus.
previous Newquist, second Freeman, all in favor?
Aye.
Those opposed, same. Motion carries. Now to approve it as amended.
Motion Nucleus.
Motion Newquist,
Second Butler.
second Butler,
Previous one.
previous Logan, second
Second
Richmond, all in favor?
Aye.
Motion carries. Anybody opposed? No opposed? Okay, there we go. We made it through the whole pile except for chapter 75.
And by next week,
We'll have it all for the.
I'll have all the nines to you.
Okay.
It's short.
They're similar.
I'm gonna try to make it to Rotary, guys. Can I, let's see, the rest of the agenda. Sorry. I got too excited. Any other new business? Any announcements? I do have an announcement. I'm gonna speak to the chair about adding an ordinance regarding our building security, and I have no need for executive session. Motion to adjourn? Motion to adjourn, second Freeman. Those who want to stay, go right on ahead. But we're out of here. Like a herd of turtles, Myrtle.
You get to print more stuff for us. I appreciate all of your printing.
Sandy, when I come in tomorrow, I'll send you those amended ones. I got like 2 or 3 that were amended. I'll send them to you tomorrow.
Okay.